Hi, welcome back. This is Hilary Garcia. I'm a healthcare attorney with Disability Rights Texas, and this is session 2, the appeals process, on our 3-part session on Medicaid denials and appeals. So we want to emphasize with the right to appeal that, again, there is this requirement that you're notified 10 days from the date of your actual notification on when the decision that the managed care company has made will officially go into effect. It is important, again, that especially within you look towards that effective date, because the effective date, again, could be longer than 10 days. Legally, it has to be 10 days from the date of the letter. But I think most managed care companies and other agencies are aware that you may not receive, the decision timely via mail. So just because it's dated a certain date does not mean that within 10 days you're going to receive that letter. So typically they give you a little bit longer than 10 days. So whatever the effective date is should be, as required by law, 10 days from the date of your letter. If it's longer, the importance of that date is that you have 10 days from that date of whatever the effective action date is to request continued services, which, as we mentioned in session 1, is going to be really of vital importance because the appeals process can take months to completion. And if you don't have maintained benefits, you're going to go back to the reduced rate until the outcome of the appeal. And that includes also the outcome of the Medicaid fair hearing. So who exactly can appeal? Now, the letter will tell you who's able to appeal, but the individual themselves, the beneficiary, your guardian, legally authorized representative can also appeal on your behalf. If you have or if you do have counsel already retained, which sometimes at the appeals process you may not, that's okay. You have time to try and retain or seek counsel or an advocate to help you. But at this initial phase, they are allowed to ask for an appeal on your behalf, so long as they have a release to establish that they're allowed to do so. When it comes to how to appeal, there are multiple ways. The one thing to note is what we normally advise our clients is that although you can ask for an appeal orally, they're still going to, the managed care company is more likely than not going to ask that you still submit something in writing. So whether it be you're filling out their form, you're emailing your service coordinator, you're putting your request in some form of writing, we always advise that we feel it's best that you do still request it in writing, even if you want to choose to ask for it initially over the phone. Because oftentimes you might get a call that you're going to receive a letter that your service is going to be denied, or your service coordinator with the managed care company may call you and say, we noticed that it has been delivered and denial notice, has been delivered to you, and might ask you how you're wanting to proceed. So your coordinator might help you with that process to request it orally. We still advise to request it in writing so you have a paper trail of the actual date you requested it. And if you do ask for it orally, be sure to write that down somewhere. Most of our clients write it down on their denial notice, which is just great. So if you talk to your service coordinator the day that you have the letter, document that. If it's not that exact date, just put the time, mention that you asked your service coordinator for an appeal, just so that you can go back, especially if you have an advocate or counsel that's assisting, and say, like, no, I've requested it on this date. I requested continued services also, same date and time. If you, again, what we would advise is that you always ask for it in writing and do request some sort of notification or date stamp so you're aware of when it was submitted. So if you mail it out, if you're faxing it out, keep confirmation of the date on when it was sent out. Because again, continuation of service is very important. That's really where you have to kind of make these requests because the timelines are very long. 90 days, 120 days to request appeals or fair hearings, you have a decent timeline. But continuation of services is so important that it does require you to be a little bit more aware and cognizant of when things are requested. So if any mistake is made, it can be easily correctable because you've documented, this is when I requested it. This is when it was sent out. This is when it was confirmed, received, or delivered. We, again, just want to reiterate that there might be some services that cannot be continued during appeal. So if there is not a service that's currently in place, but you're asking for it, if you've had the service before, but you lost it at that amount, and you're requesting an appeal because of a new request, so let's say it's a nursing service or therapy. If it's nursing, let's say you used to have 80 hours per week, but you lost an appeal, you went down to 60. If they request 80 again on your behalf, even if you request continued services, you're only going to continue the 60 hours that you're approved for. You're not going to continue the 80 hours because you previously lost them. Now, if it's a service that you've had, so let's say you had physical therapy, you might have initially had 3 times per week, you went down to 2 times per week, but you're wanting to keep the 2 times per week. If you get a denial notice and you request continuation of services, it's going to continue at the 2 times per week because you've been receiving the 2 times per week. If it's a new request, so your very first time asking for therapy services, your very first time asking for nursing, although you might have been seen by the therapist, although a nurse might have come into the home initially, it's not technically a service that has been continued because it's new. So you won't be eligible to receive continued services, even if you request it. So even if you check the box and say, yes, I want services to be continued, you'll be notified that legally you don't have, or more often that the MCO does not have to provide the service pending appeal because it's new. There is a new information on continuation of services or a new time frame. Normally, this is why we tell you to pay attention to the effective date, because for the most part, it was always 10 days from the date of your letter. Which, as I mentioned, with mail problems, you don't typically receive it the very first day that the date is issued. So if it's issued, let's say if you have a decision that's sent today, January 9th, you're not going to receive it via mail January 9th. You might receive it by Friday. And so if you get it by Friday, then that means you still have to look at the January 9th date on the letter, and you have 10 days from that date, even though you lost time because you didn't actually physically receive the letter until Friday. That's why the effective date can be important, because although your date of the letter might be January 9th, the effective date might be January 17th or 21st. Whatever the effective date is, you have 10 days from that date to request continuation of services, which is a lot longer of a deadline than the 10 days you have from January 9th. So that's why it becomes important to kind of consider the effective date on the letter versus the date the letter was actually issued, because the new rule allows for whichever is later, which is always going to be the effective date versus the date of the letter that was issued. Again, we stress the importance of continuation of services, because especially when you have an advocate or counsel involved, that's always going to extend potentially your ability to proceed to a fair hearing quickly, because you have to someone's going to help you prepare for a fair hearing. Someone's going to help you prepare potentially even for an appeal by submitting additional information. So the timeline that they traditionally give you to make a decision, if you have someone helping you submit additional information, if you have someone helping you with the fair hearing, it's going to take some time. And when I say months, I do mean months. I don't mean that it's going to be resolved really quickly, because again, you have to receive information in writing. So the worst thing that can happen is if a client doesn't request continuation of services and we finish a fair hearing, so we they worked through the internal appeal. They were unsuccessful. They've requested a Medicaid fair hearing. We worked through the fair hearing process. So in combined, it could take 3 to 4 months until we get that final fair hearing decision. The worst feeling is winning at a fair hearing and knowing that the client missed out on 4 months of services, because you don't get that time back necessarily. So yes, you get an approval, but the whole time that we're waiting for this process, waiting for this final outcome, you went without, or the beneficiary went without. And with services like nursing, therapy, those are very important services and benefits that you're missing out on because continuation of services was not requested. So please, please, please be very aware that we always advocate for continued services. So one of the things that sometimes can arise is if, like, how exactly does the continuation of services tend to work? So depending on the service, whatever it is, like we mentioned, nursing or therapy, the agency will receive authorizations to continue the service. So they might have told you, like, we're aware you have an appeal, you have to, like, we haven't received an authorization to extend things yet, so services might stop on this date. Although the agency can tell you that, they should also make you aware that as soon as they receive the notification and you're eligible for continued services, because you asked within the 10-day time frame, they will get the authorization sent automatically. Now, we have had clients where it's become an issue where they send it too close, prior to the end of the authorization, where the agency's calling you and saying, hey, we haven't received anything, what's going on? But most managed care companies are very good at keeping up to date the authorizations with your health plan, so that there's never a gap in services or coverage. Sometimes agencies won't potentially resubmit. So what you also have to consider for certain services, like nursing, they might be 3-month authorizations. As I mentioned, sometimes the appeals process to a fair hearing can take a few months. So your agency, your nursing agency, will still have to submit for services, even if you're pending appeal, even if they have an authorization already on file for continued services. Now, more often than not, when they submit, they're just going to receive the continuation of service authorization, but they still have the obligation to continue to update the managed care company. It also becomes important that, because the process can take some time, that if anything changes, even if they have a continuation of service authorization, if there are significant changes in an individual's condition and or needs, that has to be made known so that they don't just get another, like, here's the authorization because they asked for continued services, we have to wait for the outcome of the appeal. We mentioned this about the arbitrariness of the authorization dates, because some managed care companies, although they're also aware that the appeals process can take such a long time, they will issue like month-to-month authorizations. So they'll wait until, like, it's not until the date of the fair hearing even, because unfortunately, as I'll mention a little bit further on, at your Medicaid fair hearing, you don't receive a decision on that date. It has to be put in writing, and it can take a couple weeks to a couple months to issue a decision. So some health plans will put it up until the date of the fair hearing, which just means that they're going to have to issue another authorization, because you're never going to receive a decision that date, because it has to be in writing. So that's just something to consider. Your agencies might mention it, like, we just received a month off. Do you know what's happening? That's very common. That just means that the MCO is going to keep following up and issuing new authorizations so that there's no gaps, or there's no issues with continuation. Again, one thing to be cognizant or aware of is so let's say you went through your initial appeal, you asked for services to be continued, pending that initial appeal. You got your secondary denial notice, which is your final denial notice from the managed care company, and now you're requesting a fair hearing. You still have to request continued services for the fair hearing process as well. It's not going to automatically continue. Now, it should say on the form as well that you're filling out that you're also requesting continued services. But if you request it orally, just be sure to also mention, like, I want continued services. And then again, note that you not only ask for the fair hearing, but also continuation of services. Note the date, who you spoke with, put that also on the denial notice or somewhere on your documentation so that you can be aware that if someone asks you, you've documented date, time, who you spoke with, and that you also requested continuation of services. So we hope this information was helpful. You can always seek further assistance from these organizations as well as Disability Rights Texas.
For assistance with Medicaid appeals, call our intake line at 1-800-252-9108 or visit www.drtx.org/Medicaid appeals to find our related self-advocacy resources.